Alex here with a legal nuts and bolts video on tender. I found out that tender is basically the point at which a person has actually attempted to make a payment. And it seems kind of like an obvious thing, but there are situations where it becomes relevant because the person that the other person or entity tried to make payment to refused to accept the payment for whatever random reason. Um, the principle of tender, or maybe it's just considered a definition or something, comes up in certain cases where if a payment isn't made, it could trigger some kind of legal action. The example that I was going to bring up was a landlord-tenant example because it's something that's happened to me a bunch of times in my landlord-tenant experiences, just in my own ordinary experiences with landlords. But then I'd say over the past 8 months, I've seen like 50 different Supreme Court appeals come down where the same exact thing was happening with HOAs. They were doing it to, I want to say banks, I guess mortgage holders or loan servicers, whatever, the person who held the mortgage on a home. Same exact thing that they were doing to them, so I decided to make it a landlord-tenant video and just talk about tender generally. To prevent, in certain legal situations, to prevent the adverse side, the other side, from using some kind of special legal instruments. I call them sometimes special powers, because that's kind of what I'm getting down to when I talk about landlords and tenants with regards to their ability to use the summary eviction for non-payment of rent mechanism. And then with the HOAs and banks, it's the super priority lien. I'll talk really quickly about both of them. I guess HOAs have this power to sell someone's house out from under them if the amount of a super priority lien isn't paid within a certain amount of time. And what it includes is costs for assessments that haven't been paid. I think it's got to be a certain number of months, something like 9 months worth of assessments. And also, they can include fines associated with nuisance violations, and there may be something in there about maintenance. These specific costs that are due and owing to the HOA are considered the super priority portion of a lien. A lot of times the lien itself is much bigger. It has all kinds of other costs and fees included in it. For the most part, it tends to be collection agency fees. There's some situations that are really ridiculous where it's like $250 in like assessments. So the super priority lien might come out to like $250, and then the rest of it may be $3,000 just in fees and fines and collection and contract costs and all that. It's ridiculous. It can happen, and it does happen, and it makes people just really upset, and they try to refuse to pay, but they'll get this lien on their home and this threat to basically evict them and sell the house out from under them for a very low price. It's really unfair. Anyway, I think I mentioned earlier that it was a whole bunch of decisions, but it was banks and loan servicers and stuff that kind of underlines the whole problem of the average person not being able to get to the Supreme Court and resolve these issues. But the banks could a whole bunch of times, several dozen times. They won appeals. They got decisions from HOAs reversed on appeal so that they couldn't, sell the home and leave the bank high and dry or whatever. It's interesting. It's too bad that an ordinary person couldn't be the first one to really blaze that trail, but oftentimes it comes down to a whole lot of money. And then with the situation of landlords and tenants, it's the same thing. It's another superpower, though. With them, it is the summary eviction for non-payment of rent mechanism. Landlords love this in Nevada. In fact, I think probably it would be higher than 99% of evictions that go through this summary eviction for non-payment of rent. As you can tell by the name of it, it's for not paying rent. But as with I'm talking about abuses in this video, you can guess that what's happening is that the landlords are trying to use the summary eviction for non-payment of rent, and they're throwing in all kinds of other costs. There may be fees or fines. There may be something in there about repairs, disputes for repairs, things aren't being fixed. They just lump that all in there to the summary eviction for non-payment of rent, and they say if you don't pay it all, you're getting evicted. And they, like as I mentioned, refuse to take partial payments. So if a person goes up and says, you know what, I'm just going to pay the rental portion of it so that you can't evict me under the summary eviction for non-payment of rent. If you want to collect the rest of it, I want to fight you in court. in an ordinary court. That's not going to be 15 minutes, real quick. I'm serious, they're so fast. If you get a notice of non-payment on your door, you have like 5 days to file some kind of affidavit of tenant with the justice court. And if you don't file it, you're done for. Within 2 days, they'll get a lockout order. And then when it comes to, if you do file it, you'll get your hearing probably 3 or 4 days later. And then again, if you lose that, 2 days later, lockout order. It's insanely fast. And it's cheap. That's why the landlords love it. They don't need an attorney. They can just show up. Some of them do bring an attorney, but most of them don't. Anyway, what they try and do is lump all these other fees and costs into there, and if you don't want to pay it, too bad. You better pay it, and if you try to pay just the portion of the rent so you can stay in your home and challenge them later, no, they refuse to take the partial payment, and then what do? They go to court and lie and say that you didn't pay anything, because in their mind, they were allowed to reject your payment in what they call good faith, which I'm going to talk about a little bit later in this video. Same thing with the HOAs. They were saying they wanted the entire lien paid off, or they would sell the house, and the banks would try and pay them just the portion for the super priority lien, not all the other extra costs they just slapped on there. And the HOA would say the same thing. Nope, not taking partial payments. And then they would go and turn around and say that they didn't pay the assessments, because technically they didn't, because technically they refused to take the money for them. So I read some of those dispositions that came down from the Supreme Court. Wanted to do a video on it to just explain it to people, to get at least the Supreme Court of Nevada, and of course any other district judge and justice of the peace in the state, to recognize a payment. You have to show that you actually attempted to make the payment. And they drew that line in several different cases. Offering to make a payment wasn't enough. An email saying that you would like to make a payment wasn't enough. You would have to actually go and make the payment and actually be refused then and there for you to be able to say later on in court that you tendered payment. That's the difference between the payment actually being accepted and payment being tendered. With payment being tendered, it's the actual step taken of attempting payment. And if it's rejected, that's not on you. You've tendered payment. I just wanted to do this video because there were some cases where I did see that a person didn't tender payment. They just sent an offer asking if it was okay to send a partial and stuff like that, and then the other side said no, they would reject it. Well, unfortunately, they couldn't get any relief in the Supreme Court, whereas all the other instances of people tendering payment, they were able to get relief. With regards to rejecting a partial payment in good faith, the Supreme Court threw that in the garbage as nonsense. They said that good faith is just subjective to whatever company it is that's coming up with the notion as to what they can reject and what they can't. And the law overrode all of that. And the law specifically stated in the case of super priority liens that only the portion, as previously defined, covering nuisance and assessments and all that, is the portion that can actually trigger a sale out from under all the other lien holders. Same thing with landlord tenants, only the portion that compromises rent. And I think they also include late fees in that. Only those portions can be used to evict someone summarily for non-payment of rent. If there's other issues a landlord has, they can't do it through the summary eviction for non-payment of rent because it's not rent. So I'm assuming that eventually somebody is going to take a similar case to the Supreme Court, because this happened to me a bunch of times, and I'm sure it's happening to a lot of people in the state, because landlords just want to make them pay, and if they don't like it, they like to threaten to evict them, because what does it do? It twists their arm, and it gets them to pay the money, not because they felt that they were supposed to, not because it was legal, but purely because they were afraid of being evicted, especially if people have families. People don't want their families to be thrown out on the street because they want to make a stand on a particular issue. So I wanted to do this video on tender because I was hoping that anyone else who dealt with a similar situation where they tried to make a partial payment and for whatever reason it wasn't accepted, it was rejected because the other side wanted more money. Most of the time, just so you know, if that's happening, there's a reason. There's something there, something under the hood that you don't know about possibly, that they're going to try and do. There's a reason why somebody would turn away money. A lot of people are perfectly happy to take a partial payment now and get the rest later. It doesn't make much sense to say, I'm going to turn down this $800 because I want to get $1,200. Most people would say, okay, thanks for the $800. I'll collect the other $400 whenever you're ready for it. Why not get a partial payment? Well, in the two examples I provided, there's legal mechanisms in place that can be used that incentivize this whole idea of rejecting partial payments. Those HOAs don't want just the assessments. They want everything. They want to be paid all the collection fees and all that. They don't care if the assessments are only $200 and the collection fees are $3,000. They want it all. Too bad, so sad if you don't like it. And then with the landlords, it's the same thing. They want all the money, or they're going to threaten to throw you out. And your family and kids and everything. It's the same exact thing. Other situations, people take partial payments, but when people won't take a partial, there's something going on. And just remember, according to this video, if you're expecting to come back to court and say you tried to make a payment but they didn't take it, just remember to look into the definition of tendering payment in your state, or if you're in the federal jurisdiction, make sure you look into it. It's probably the same in all 50 states, but I'm not sure. There may be weird examples and exceptions in your state. If it's not in the statutes and the case law, it's going to most likely be, sorry, if it's not in the statutes and the court rules, it's going to most likely be in the case law. There certainly is a whole bunch of case law in Nevada on it now with regards to the HOA and bank struggles on tendering payments. So kind of a technical, maybe even a boring video, but it's going to matter out there for some people. If you're in Nevada and you're renting, it's definitely going to come up for you. You're going to run into one of these landlords, and you may need to actually make sure that you understand how tender works. It's not enough to offer payment. It's not enough to ask and then be rejected by email. You're going to have to actually go and attempt the payment, and you're going to have to actually be rejected. The payment's going to have to actually be rejected. One last question is how to prove it. You could send it by third party, so you could have like another person that's not connected to you too closely, like a friend maybe, or even a coworker. You could have them try and go and drop the payment off for you. That way, you have a good witness in court in case they just try and lie and say you never tried to make a payment at all. Then it's going to be your word versus theirs, and that's never good. Mail, it's good and bad because they could just say it's not in the envelope. The best thing that I like to tell people when it comes to tendering payment is use bill pay. Because if you go into your bank and you actually fill out a bill pay and you send it, the really nice thing about that is your bank sends them a cashier's check. There's not really any objection out there that somebody can have to a cashier's check. Those checks don't bounce. They're special checks. Those checks have the money already guaranteed on them because the money is pulled out of your account before the check's even sent. And then the second benefit is the person who sends the check is the actual bank. So, I mean, I used this one time in my landlord-tenant dispute against my landlord. I think it was someone at Sunridge. I sent them a payment through bill pay. It was amazing. And then it came up in court, and the justice of the peace looked at them, and he was like, summary eviction denied. And then I just gave them the cashier's check that they had earlier refused to accept. A bunch of nonsense, but little tiny details like that, so little details on something like what is tender could make or break a case. So with that, I'm going to go ahead and end this video, and I'll see you guys next time.